All right. Thank you all for being here today. I especially want to thank the Nicholson team for inviting me to talk about sexual abuse litigation. Sexual abuse litigation is a very, very large area, and to condense it all down in 45 minutes is incredibly difficult. But what I'd like to do today is I'd like to break this into essentially two different areas. The first is we're going to talk about some of the law, some of the issues that one should be aware of. And then the second part, we're going to talk about the fun stuff. So counsel new to this area need to really think about the fact that this is a very specialized area of law. It is not for the faint at heart. There are a lot of complexities within the law itself. There's a lot of ups and downs with the case law. Sometimes you see decisions that are completely contradictory to each other, and you've got to ask yourself why. There is mixed messages sometimes coming from appeal courts as well as the Supreme Court. Seems as though the Supreme Court, every time they try to talk about causation in this area, it gets more and more confusing. Now, the other thing that new counsel should think about is that this is an area where your clients themselves are not your typical personal injury clients. There's a lot of differences between a sexual assault client and a regular personal injury client, and that we'll get into a little bit later, but that is something that needs to be thought of. The last thing is that this is a relatively close bar, and pretty much anyone would be willing to assist you if you're interested in getting into this area, or if you have a case and need some advice or counsel, or just frankly just a good ear to listen to. So I definitely think that anybody wanting to get into this practice area, or if you have a case in this area, please reach out, and we would be more than willing to assist, because the better your result is, the better it is that we can also help our clients, of course. Now, what sexual abuse, though, is really only personal injury litigation. It involves the same principles at a large scale, and frankly, a tort is a tort, of course, especially if it's a chocolate tort. But in any event, it is the same area. You've got to prove your damages. You've got to prove your liability, and you also have to figure out whether or not the defendant can, in fact, pay for the judgment or settlement. This is true of any personal injury case. In sexual assault cases, it's interesting because there isn't something like guaranteed insurance like there is in most motor vehicle cases. In sexual assault, we really have to try to figure out whether or not the entity that we're suing is going to be able to pay, or if there's insurance behind that entity. The major issues involved with sexual abuse litigation are around the area of causation and of damage assessment. Now, causation and damage assessment are very, very large topics. And what I can say about it is that causation is most of what it is that we fight about. What caused what? The fact of the matter is that you've got plaintiffs who have incredibly complex lives that are made even more complex by the various tortious and non-tortious elements of their life, pre-abuse and post-abuse. These damages are also incredibly difficult because they're almost entirely always psychological in nature. And that makes it extremely difficult to try to take out and tease out what was caused by the abuse or assault, and what was caused by everything that happened to that poor person beforehand and everything that happened afterwards. There are some cases that will help with that, and we will talk about those in a bit. But damage assessment, you have to be aware, is almost always purely psychological. Very rarely do you have a situation where there is physical abuse as a result, physical damage as a result of the sexual abuse? Sometimes there is, and in those cases, sometimes it's quite easy to show where the damage is, but more often than not, the damage that you're looking at is in fact the result of psychological injury. The causes of action in these cases are quite a few. Negligence being the one that we like to try to deal with most often if it involves a third-party institution. In cases of sexual abuse, you've got the cause of action against the actual perpetrator, the actual one who's done the physical assault. However, the fact of the matter is that more often than not, that person is either dead, if in fact it was a childhood sexual assault, or that person is completely and utterly impecunious or does not want to engage in the legal system, and makes it very difficult to find that person or to serve or to whatever else. And good luck trying to then enforce a judgment on somebody of that nature. So in our practice, what we do is we always look towards somebody who in law is also responsible for the sexual assaults. And more often than not, that becomes some sort of institution that either allowed the assaults to happen or failed to stop them, or somehow or another is in law responsible for those assaults. Institutions can be pretty much anything. In childhood abuse cases, it's pretty much any kind of institution that deals with children, whether it's schools, CASs, whatnot. In present day assaults, you often have situations where there is an institution such as a jail or perhaps fellow doctors in a doctor's office or what have you. In those cases, we always look towards negligence as being the first and hopefully only cause of action that we have to deal with. Negligence is exactly what it sounds like. You've got to prove all the elements that you would in any kind of personal injury action. And in these cases, you often will have to look at historical documentation with regards to whether or not you can prove that negligence. In terms of how it is that we go about doing that, it is often a question of trying to pinpoint the documents that are involved with regards to that negligence, with regards to that institution, looking at policies and procedures of that institution, and as to whether or not those policies and procedures have been followed. In some cases, it is a lot easier than others. In some cases, it is very clear cut that there is negligence, and those are the cases that we quite enjoy because it's a lot easier, obviously. But in other cases, you really do have to study the institution itself and the policies and procedures of that institution. One of the things to keep in mind is that the negligence has to be with regards to the date and time that the assaults occurred. So it's not the policies and procedures of today, but it is the policies and procedures and everything else that was involved at the time that the incidents occurred. And in historical cases, you're looking at going back decades. We've gone so far back in time as the late 1940s, and it is often very difficult to find any kind of policies and procedures at that point, and it is also next to impossible now to try to find somebody who has any kind of actual experience with those policies and procedures. If that happens, we sometimes turn to academics, and that is sometimes the only way that we can somehow show that something that ought to have been done at the time wasn't done. If negligence is not an option, or if negligence is not as clear cut as you'd want it to be, the other way that we oftentimes will prove liability is through the doctrine of vicarious liability. Now, vicarious liability, as I'm sure many of you know, is the old master-servant doctrine of if you are my employee and you do something I'm responsible as your employer. Now, that doctrine works exceptionally well in cases of non-intentional torts. So, for instance, I always give the example of where if I've asked my clerk to shovel the snow and put salt outside of the office steps, and he fails to do so, and somebody slips and falls and hurts themselves, then obviously the vicarious liability is mine. It was his negligence. I'm the employer. I'm responsible. That doctrine does not work particularly well when you're talking about actions done by somebody who are criminal in nature. And of course, we all know that a sexual assault is criminal in nature. These assaults, these intentional acts, what you would think would take you out of vicarious liability, because I, as the employer, would never want my employee or somebody working on my behalf, even if it's not an employee, to do something criminal. However, the courts have carved out certain exceptions to vicarious liability. It is available in certain situations as of almost right now. For instance, in cases of clergy abuse, the Supreme Court of Canada has made it very clear that in clergy abuse cases, the religious institution is responsible for any kind of sexual assault done by clergy on parishioners. It gets a little bit more difficult when you're talking about non-clergy and parishioners. Sometimes if you're talking about, for instance, an elder at a church or a youth leader, you may be able to show vicarious liability as well. In other cases, you really do have to go through the steps of vicarious liability, and those are very difficult steps to go through and a very complicated area of law that would take up the better part of the next half hour that we have here. What I would suggest is you read the cases with regards to vicarious liability and reach out to somebody with some experience in this area. It is not easy to go through. Judges find it very difficult to go through, and judges have found it often, or we have found that oftentimes it is a real step in educating judges who have not dealt with these kinds of cases as to the step-by-step process that is needed to determine vicarious liability. There are some other causes of action, breach of fiduciary duty and breach of non-delegable duty being two of the ones that can often happen. Occupiers liability is sometimes something that we can work with, but again, those are very, very specific to the cases at hand, and usually get subsumed within either vicarious liability or negligence. The breach of fiduciary duty one, I may add, is very difficult because the steps involved in showing the breach of fiduciary duty on an institution are very different than they are on the actual perpetrator. The actual perpetrator, if that person is in a position of power, such as a priest or a parent, the breach of fiduciary duty is very easily proven. In a case, for instance, of a children's aid society, the breach of fiduciary duty is not so easily proven, because not only do you have to show that something was done against a particular child, but you have to show that that institution somehow did not pursue the best interests of that child even afterwards, in terms of for instance, hiding what happened or things like that. Then you may have breach of fiduciary duty against an institution, but not necessarily. It is a very step-by-step process. Subrogated claims are something that we also have to consider, because in many of these cases, there is an awful lot of treatment that is provided, or insurance, disability insurance that is provided to our plaintiffs. And we always have to keep in mind that OHIP and other provincial health insurers, as well as third-party disability carriers, also may have a claim as well and may need to be dealt with. So that is something that you start with right at the beginning to alert them, and see if they want to participate and get their subricated interest. And that is important, because otherwise it becomes a real issue later on to your plaintiff when somebody's coming after them because they didn't pay back their insurance or whatnot. In most of these cases, what we try to do is we try to fill the statement of claim with as many possible causes of actions as we can think of that obviously are appropriately pleaded and can actually happen if proven, and hopefully one of them will pan out. Sometimes it's difficult to know at the beginning which one is going to be the one that liability will rest on, simply because there's an awful lot of documents and an awful lot of information that comes out through the discovery process, both documentary as well as examination of discovery. Now, there are a lot of cases, and I've listed some here, and I know that will these slides be available afterwards to people?
Yes.
Yes. Okay, good. So I'm just going to go through these quickly, because I think that going through them, each one is very long. But as far as case law with vicarious liability, Basil and Curry and Jacoby and Griffiths are the ones that are absolutely foundational pieces on how to determine vicarious liability when it comes to an intentional tort. I urge all of you to start with those cases first, and then move on to see if there's any other case that may be specific in the case that you're dealing with. Teacher student abuse is dealt with through John Doe and Avalon East School Board, and the much newer case C.O.M. Williamson, which is a masterclass in the applicability of vicarious liability when it comes to student abuse and school boards. There are some non-vicarious liability cases as well, and I've listed them there. And I also think it's important for you to look at those, simply because it may give you an idea as to what some of the hurdles are. Again, there are lots of other cases with regards to aggravated damages, negligence and breach of fiduciary. Those are the cases that may be of interest to you. One of the things as well that you as plaintiffs lawyers need to consider is insurance coverage. And sometimes there is an awful lot of back and forth between the insurance companies as to whether or not there's coverage in your particular circumstance. This, while it doesn't necessarily relate to you specifically, does come into play, because if there is no insurance coverage found, then that creates some very, very big problems down the road, even if you are successful. These are the other cases that are also very important in the discussion of liability when it comes to sexual assault claims. Snell and Farrell, an oldie but a goodie, and all the rest. Nash and McDougall, the last one there, is one of the easiest ways to look at causation. It's a really, really good case that deals with the causation of whether or not what happened in the sexual assault is enough to show that damages flow from that sexual assault. So I urge people to read those cases as well. One of the other things that is often important in the discussion of sexual abuse is whether or not, as a plaintiff, he or she wants their name out there. And you will see a lot of sexual assault cases go by their initials or Jane Doe. And there's lots of different reasons for that. Oftentimes, there's a lot of consideration on the plaintiff's family. The plaintiff does not necessarily want their family to know exactly what's going on, their extended family. Usually, more often than not, it's also that the plaintiff doesn't want to put their family, especially their children, in the limelight as well, especially if it's a case which may garner some media coverage. So whether or not pseudonyms are appropriate is something that you do need to speak to your client about prior to issuing that statement of claim, because once it's issued, cat's kind of out of the bag, and you've got to deal with it prior and take the steps necessary to file with pseudonyms. I want to go back to insurance coverage for a moment. Now, this is not necessarily something that is important for you as plaintiff's counsel to do. In fact, you can't generally do it because you're not privy to that contract. But I have often found that you are able to assist defense lawyers, defendants counsel, especially if defendants counsel does not know how to go about dealing with this claim initially. And sometimes you will find that an institution or even an individual, for instance, a non-offending spouse, will find a lawyer that does not specialize in this area. And it is important for you as plaintiff's counsel to try to assist that defense lawyer as much as possible. Now, some defense lawyers will not want to hear about your help, but if they do, some of the things that you can help them with are trying to find that policy, looking up different ways of trying to find that policy, sometimes finding current insurance brokers or insurance companies actually leads you back in time through the policies. So those are some things that you really do need to think about. Productions in these cases are pretty much the typical productions that you have in any kind of sexual assault. The difference, however, in these cases is that we get everything that we possibly can prior to the issuance of the statement of claim, especially when you're dealing with a long-time sexual assault, a historical sexual assault. It is imperative that you get as many of those documents as possible going back throughout the person's lifetime, especially if it happened in childhood, because it will lead you to different things and other productions that will become necessary that your client simply forgot. For instance, we often will find names of other treating doctors or treating psychologists within the clinical notes and records of the current psychologist. Client may not remember who that person is, may not even remember that they even went to see that person. Getting those documents and making sure that you know what's in them and you're prepared to make them even better or to inoculate any problems is very important. That is why in most situations we do an awful lot of back-end work prior to issuing that statement of claim. Examinations for discoveries are examinations for discoveries, and preparing your client is very difficult in these cases because clients are oftentimes very reticent to talk about their story or unable to talk about their story in different ways, and we will get to some of that. The alternatives sometimes are frankly written questions or considering whether or not the information that defense counsel would get through an examination for discovery can actually be gotten through a much more informal process. We have sometimes defense counsel that agree to come to our office and just sit down and talk to our plaintiff. Usually that's a situation where the defense counsel really does want to simply assess the plaintiff's credibility and wants eyes on that person because most of the information is available through the documents or can be shared through written questions. Sometimes it works, sometimes it doesn't. The expert witness in this case is very important. Expert witnesses can make or break your case. Obviously, getting a psychological impact assessment by a competent expert is the most important step, as is getting any kind of cost of care or economic loss report once the psychological impact assessment is done. Your damages in these cases are wide-ranging. The general damages are generally set somewhere between, give or take, 125 to 400,000 for most sexual assaults that are invasive and ongoing. The fight is about economic loss. In almost all of these cases, the difference between what a plaintiff's lawyer thinks general damages will be and what a defense lawyer thinks general damages will be is not that big. The fight is absolutely about your economic loss or your client's economic loss. And this is because sexual assault generally doesn't happen in a vacuum. And if it's childhood sexual assault, you don't know where that child would have gone. And in many of these cases, your client was from a home that had some issues to begin with. So there is causation issues, and that's why damages in terms of loss of economic advantage or income loss are very difficult. Mediations are mediations. The likelihood of success depends on how much you've been able to show the defense that they're going to lose at trial. And that's true of obviously any personal injury case. Important, however, to find a mediator with experience in this area. The experience in this area is paramount, because the last thing you want to be doing is educating the mediator on the case law in this area. You want a mediator that is trusted by both sides and that the defense counsel will hopefully listen to. One of the things that is very important and sometimes incredibly different in these cases is that you do not want openings. In almost every case, an opening by defense counsel of anything other than, we're sorry this happened to you, we're here to try to resolve this, is going to create a negative impact on your client, which will make it more difficult for your client to deal with the rest of the mediation. So in most of these cases, we do not have openings. Most mediators with expertise in this area also, frankly, discourage openings, and most defense lawyers also discourage openings. Pretrials, exactly that. They are pretrials, and hopefully you will get a judge who has some prior knowledge of these cases. Now, the next part of this webinar is really about the real difference between sexual assault and regular personal injury. Personal injury clients, as a rule, are often more challenging than a real estate client or a corporate client, because obviously they have suffered some sort of trauma, and that means that their life has been changed, and that's why they're you. Your typical sexual assault client is kind of the same way as a typical personal injury client, but on steroids, and I am not kidding. It is very important for you to understand from the get-go that sexual assault is not about sex. Sexual assault is about power, and it is about taking power away from somebody. And when power is taken away from somebody, especially if it's not only psychological and emotional power, but also bodily autonomy power, it creates some very, very difficult things in people. This often translates to survivors having so many different problems that are both psychological, emotional, and frankly, organic. It's important to deal with these clients in a trauma-informed way. And trauma-informed isn't just simply being nice to your client. It's not simply listening to your client. It is understanding that the trauma itself, the sexual assault itself, or the horrific car accident, for instance, itself, especially if they are repeated. So if you've got repeated sexual assaults, what happens is that there are actual neurochemical and neurobiological changes to the brain. And when you've got these changes, when you've got the chemicals, the neurotransmitters assaulting the brain all the time, it actually creates changes to different structures in the brain, the hippocampus and the amygdala being primary structures that are changed because of intense trauma. And these are exactly the areas of the brain that control emotions, that control memory, that control the ability to relate to others, all of that. Understanding that is important and of paramount importance in any kind of sexual assault practice, because it allows you to help clients better. These clients are often completely traumatized by what happened, and often are traumatized severely and have post-traumatic stress disorder or complex post-traumatic stress disorder. And they are unable to relate to others in the same way as somebody who's had a broken leg as a result of a car accident or a slip and fall. The issues become mostly emotional, mostly psychological. These are some of the typical concerns that clients come to us with. And this is all part of that neurobiological and neurocognitive changes that happen within the brain as a result of trauma. What that often does is it also changes the ability of a person to remember what happened. And the reason for that, again, is because of the biological and chemical changes, but it means that people will sometimes clam up and not remember what's going on. It's that whole fight, flight, or freeze response that is not only caused at the time of the actual assault, but because of those changes can be re-triggered during times of stress, or if there's a trigger such as a smell or the way somebody looks, or even just frankly thinking about the trauma. If that happens, that client is back in fight, flight, or freeze. That's what a trauma-informed approach means. It's understanding that, and it's understanding how you take that client and you are able to move them to a place where hopefully they are calmer, but more importantly, for you as a lawyer and not somebody's therapist, it's important for you to understand it because it's what you need to explain to the other side. It's what you need to explain as to why some of the memories may be a little bit different. It's what you need to be able to explain and get that information out in a way that our legal system wants it to be heard. If you understand that, you will definitely be able to help your client more. Again, a trauma-informed approach is something that goes far beyond this kind of webinar, but it is something that I really do stress is incredibly important for sexual abuse practice, and frankly, as far as I'm concerned, for all areas of practice, because we as lawyers deal with people, and people have trauma, even if they don't appear so. You know, it's a completely and utterly corporate business deal. You may still be dealing with somebody with trauma. So taking a trauma-informed approach in law is something that is very important, but especially in personal injury cases, and absolutely necessary in our kinds of sexual assault cases. There are different kinds of survivors, and each one of them is important to understand, because you may be able to assist in ways that are more helpful. Most clients will have trust issues. Rarely do I have a sexual assault client who does not have major trust issues, because trust was broken in that sexual assault period. So trusting is something that is very difficult. Clients who especially have complex PTSD and have childhood assaults have a fundamental belief that pretty much everybody will eventually hurt them. The way that you can deal with that is to show them that you understand that trust is earned. Take little baby steps towards that. Keep your word. That is so important in these cases. Explain what you're doing behind your advice. Explain that while they're in the office, in any event, this is a safe place for them, and they're not going to be judged, and they're going to be heard. And even if it takes a long, long time to get their story out, you're not in a rush. Very, very, very important. The other thing as well, for most sexual assault clients, don't wear a suit. Don't do it. Be casual. Not sloppy, obviously, but don't wear a suit. A suit is a sign of authority. You know, lawyers have authority by the fact that we're lawyers. Try to diminish that. Try to make your client at ease. It's really very, very important. Clients are oftentimes very hostile. We have had clients that are incredibly aggressive and even violent in the office. It's often a real issue. And of course, I urge you to take absolutely every precaution that you possibly can to keep you and your employees safe, but it is something that can happen. The violence is usually not directed to the lawyers themselves, although it can and has been, but it is often aggressive, you know, pounding fists on the desk, things like that. These kinds of clients are the ones that have the most extreme distrust. They're the ones who will accuse you of being in cahoots with defense counsel. They're the ones who will absolutely accuse you of absolutely everything. In these cases, you still have to have that trauma-informed approach, but it is also very important for you to document everything that you possibly can, and often urge your client to get a second opinion from a different lawyer, because sometimes that helps calm them down that, yeah, what you're saying is in fact in their best interest. Non-disclosure clients are fun. They're the ones who don't tell you what's going on. And oftentimes they don't tell you not because they want to keep something from you, but it's because they think that you don't need to know everything. That is absolutely the worst thing that you can do, is not know everything. It is very, very important for you to be able to coax the whole story out of your client. They need to understand that the more that you know, the more that you can help them with their case, that you're not judging them, that you're not trying to hurt their case, you're trying to help their case. If you know of something that is possibly hurtful beforehand, you can usually deal with it. If it's a surprise, it's a problem. This is why we look at the records incredibly carefully. This is why we get those clinical notes and records, especially any kind of psychological record prior to issuing the claim, because you do not want to have surprises. You want to make sure that you know absolutely everything. And oops, your client forgot to tell you that, they were sexually assaulted by somebody else afterwards. They may not want you to know that, but it's incredibly important for you to know it. Absent clients are the ones that are just disappear. It happens all the time. And it happens all the time because of that fight, flight, or freeze response that clients will often have. You can't find them because they are too afraid to be found. They are frozen. They might be in jail. A lot of our clients do have criminal histories in their past and present, and you want to find them one way or the other. Again, do the typical things of documenting what it is that you've tried to do. Try contacting family and friends if you have that permission to do so, which is often sometimes something that we ask. And consider that they may not want to be found and have taken the ultimate step not to be found. That has often happened, so you may want to look at death records as well. Differential clients are the ones that will just want you to do everything. They say, you do everything and call me when it's done. Often they will feel like they're a burden to you, or that they don't want to take up your time. These clients are often difficult to deal with because you really do have to explain what's going on and get them to understand that this case is not about you, but it is about them. What they're doing is they're trying to get you to somehow validate what's happened to them. So validation is always an important step for all clients, but with differential clients, especially important step. Again, this is always the typical advice of documenting instructions, all of that. You can help them make a decision, but you yourself obviously can't make a decision. I will often say to clients when they ask me what to do, I will often say to them, as a lawyer, you should take or not take the settlement, but as a person, you've got to consider the following. And most of the following is what the settlement will do, not to their financial health, but to their emotional and psychological health. And that's where these clients are different. And that's where a deferential client is even more difficult, because they do not want to make that decision. This is where you really do have to get them to make that decision. Sometimes second opinions are helpful. Sometimes enlisting the help of one of their therapists, obviously with consent, will help that client get to the point where they are able to make that decision. Needy clients are the ones that call often. And by often, I mean every day. I know that there's a lot of personal injury clients that do that as well, but sexual assault clients want you to be their absolute everything. They want you to be their therapist, their social worker, their friend, their partner, their mother hen, absolutely everything. These are the people that are usually alone in the world and don't have anybody. This is where it's very important for you to not enable them, set up boundaries, and try to find somebody who in fact can help them from that perspective and not from a legal perspective. Good clients are the ones that are generally too smart for their own good. They're the ones who think that they know more than you do. They're the ones that provide you with too much information, including what they had for breakfast that morning. But often I find that these are the clients that are very difficult to manage because they do hold you in some ways to a higher level because they've done the work for you. I've often heard that. They're difficult to manage, but what you need to do is you need to set up those boundaries, set up those expectations, and keep to those. And of course, always in writing. Sexual assault litigation is, again, something that is not for the faint of heart. Your own mental health and the mental health of your staff is also of concern. That is part of the trauma-informed approach to lawyering, because these are not easy cases. They are very, very difficult emotionally. You are hearing people who have suffered the most heinous of crimes, especially in childhood, and you can and often are brought into that kind of trauma, and you yourself will sometimes have vicarious trauma as a result. It used to be called secondary trauma. The catchword now is vicarious trauma, but it means the same thing. You go home, you keep thinking about it, those images come back into your head, it disrupts your own emotions, your ability to sleep, all of it. We've all had clients who hit you more than others, but in sexual assault clients, the graphic images that they have to tell you about are horrific to go through and horrific to listen to. Your mental health is very important, as is that of your employees. The benefits of doing this kind of work is that you are helping somebody in their healing journey. You know, yes, you want to give them justice, whatever the heck justice means to them, and whatever pale justice our legal system can give them. But really and truly, what you want to do is help them on that healing journey. And, you know, the healing journey is exactly that chart. You know, you expect it to go one way and it goes up and down, squiggly, and sometimes it goes way down before it comes up. But in this whole approach, and the reason to do sexual abuse work, and what's really important in sexual abuse work, is to promote that healing and not cause more harm. And to do so is a privilege, in my opinion, because helping somebody who is really at the bottom of society's list of vulnerable people, at the bottom of, you know, the worst kind of horrific crime one person can do to another, to me is a privilege, and it is a wonderful area of law. But please, it is not for the faint of heart. If you have one of these cases, please do your client justice and try to understand as much as you can about the area, and so as to help them the most. Are there any questions?
I don't see any in the chat right now.
Okay.
So I'd say if anybody wants to reach out to you, Simona,
absolutely.
After, sure.
Absolutely. If anybody wants to reach out to me, please, those are my contact details. Feel free to reach out. If I am not available, one of my colleagues will be available if it's an emergency. And if not, I will get back to you and help you out as much as I can. Thank you so much for listening. The fact that you've done that is a wonderful step towards becoming a better lawyer, and a lawyer who can really help these clients. So thank you.